The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you so much. Welcome to the North Carolina Court of Appeals. My name is Judge Chris Till, and I'll be presiding today, and also will be Judge Murphy and Judge Arrowood. And we have two cases on the calendar today. The first is a criminal case. It's the case of State versus Teesateskie, if I'm pronouncing that right. And we will first hear from the appellant, Mr. Henson. So if you're ready, you'll proceed. And I understand you're going to reserve 5 minutes for rebuttal. Is that correct?
Yes, Your Honor, that is correct. Thank you.
Okay, you can begin.
Thank you. Good morning. May it please the court. My name is Warren Henson, and I represent Ms. Kimberly Teesateskie. The central question in this case was whether Ms. Teesateskie was appreciably impaired for purposes of convicting her of DWI and felony death by motor vehicle. And specifically at issue is whether the trial court erred by allowing the state to elicit testimony from its expert witness that Ms. Teesateskie could have had hydrocodone in her system, even though the state crime lab confirmatory testing could not confirm or identify it. Because the crime lab's confirmatory testing did not identify hydrocodone, and the lab's own standards and protocols prevented the analyst from reporting it out, such testimony violated Rule 702. And the principal.
Mr. Henson, did your client preserve that argument? The state contends that there's a failure of preservation here, and they're quoting from transcripts pages, I believe, 419 and 423 to 424, or in that period, and whether or not what the objections made and the comments made there were sufficient to preserve that. Can you address that, please?
Yes, Your Honor. Thank you for the question. Yes, Ms. Teesateskie did preserve this particular issue. And in reference to the transcript pages, there is a long, the state says that there was some questions that occurred prior to, an objection was made, and that therefore it was waived. But the particular line of testimony that was not objected to does not get to the central conjectural issue of whether or not hydrocodone could have been present, even though she could not confirm it. And that was the specific line of testimony that following the voir dire was objected to. And it's clear during the voir dire, there's an extensive voir dire and a hearing outside the jury's presence about this line of testimony. And it's clear from the trial court and from the defense attorney's line of questioning during the voir dire and his specific objections that this has to do with whether it's reliable, whether it's scientific, and that, I believe, brings it within the realm, makes it clear that from the context, it's apparent from the context, that he's referring to Rule 702. And specific testimony as to what the state is referring to as what they contend should have been objected to was the state asked, in your confirmatory testing only, did you see the presence of hydrocodone? And the analyst said, in my confirmatory testing, I did identify hydrocodone. However, and then the prosecutor cuts her off and says, I'm sorry, but just in the confirmatory testing or just in the screening process? And these were yes or no questions. Did you see it or did you not see it? But that's not getting into the conjectural possibility of could it have been there, but you just weren't able to confirm it? That is the particular testimony that is problematic and that violates 702. And that is when that came after the voir dire, when that line of testimony came up again, defense counsel objected. And again, it's apparent from the context of that entire voir dire where defense counsel is, he's quoted as saying, the problem is what you're dealing with it's not really what you would consider to be scientific or reliable. So when he objects during the questioning to her response, right when they come back on the record and the state's resuming its direct examination, it's clear that that's what they're referring to. And during the voir dire, the trial court even said, she can say it's either there or not there, referring to the hydrocodone. But to sit here and say, I saw part of it, we can't confirm it, I think you're going to run square into a Rule 702. So 702 was on the forefront of the minds of the trial court and the defense attorney about this particular specific line of testimony. Could it have been present, but you could not confirm it? And that, for those reasons, I believe that the issue is preserved, Your Honor.
Mr. Henson, I just want to kind of just give you an opportunity to just clarify just a little bit more for me. I think, I have it pretty crystal clear on your argument related to the preservation of 702, but I think, there's also this timeliness issue. So could you tell me just a little bit more on why the objection didn't really come like one question too late on 419?
Sure. So, yes, Your Honor. I believe if you look at, and I'm referencing transcript page 419.
Yeah. So I guess my question is, should the objection have come between lines 13 and 14 on 419 instead of not until line 21 there in the transcript?
Well, I think so. I don't think it was necessary at that particular time, those lines that you're referencing to, because, again, she's saying, did you see it, in your confirmatory testing? That's not calling for an answer that is essentially speculative as to, yes, I could have, but here's why, and even though I couldn't confirm it. It is yes or no. Did you see it or did you not? And she's going to clarify. She says, however, in my confirmatory testing, I did identify, however. And I think defense counsel could have anticipated that he didn't really know what she was going to say. Maybe it was something that he thought would have been helpful to his case. But once it becomes clear that they're going to get into a few lines down, she says, I could not get a good mass spectral identification. It's like the fingerprint of a drug, and I just couldn't get there. And so it seems at that point he knows where this is going as to, well, now she's going to say she couldn't see it, but yet it was there. And that's where the objection's made. I think that is the speculative testimony that's truly at issue. And I don't think that we just don't get there in those lines above. I think we get there later on.
Would it be your position then, I guess, you kind of argue that we kind of take the voir dire into consideration, that we're talking about 702 and that should be clear. Is it also your contention we should be considering the voir dire in terms of the timeliness of the objection and take that into consideration if we're considering the timeliness of the objection here?
Well, I think the voir dire makes the objection, once they're back on the record after the voir dire, I think that makes the basis of the objection clear, that it's Rule 702. I know the state makes it an argument that, hey, they weren't specific enough in that they just said objection. But it's apparent from the context of this extensive voir dire that what we're really talking about is the lack of scientific reliability. And defense counsel, uses the words, that it's not scientific, it's not reliable. And the trial court says over and over again, you're going to run, this is not scientific, you're running into Rule 702. So I think in terms of the nature of the objection, I think it's apparent from the context and you can consider the voir dire for that purpose. Your other question, the other part of your question, I guess, in terms of the timeliness, I don't think the voir dire, is Not, I don't think that it saves an earlier. If your point is, well, they should have objected earlier. The voir dire doesn't make it timely, but I don't think you need. Defense counsel objects before the voir dire obviously happens, and the point at which he objects is the point where this conjectural line of testimony is coming in. Could you identify it even though you couldn't see? Could you see it even though you couldn't identify? So, could it possibly have been present? That's the issue, testimony issue, and we didn't quite get there yet. And that's on page 419, towards the top of the page. And that's why I don't think he had to object at that point. But lower down in the page is where I think he does object. And I think that's because it's clear at that point, that's where she's going to be saying, she's starting to testify about, whether she couldn't really see the fingerprint of the drug, but yet she might say, I still think it could have been there. So he objects, and that's when they go into voir dire.
Let me ask you a question. Assuming that the evidence that the objection was timely made and she should not have been allowed to testify, why, in the light most favorable state, was there not at least enough evidence to go to the jury on whether or not she was impaired or not, based on all that was observed at the scene and all that she said and all that? Why do you say? I mean, you argue that there wasn't enough evidence. Are you saying without this testimony, why was there not enough evidence?
So, thank you, Judge Dillon. I believe that the evidence of impairment in this case yielded an equivocal result. And I say that because you have, when you look at all the evidence and you see from the time that the troopers arrive on the scene, that the EMS is on the scene, that the physiological indications of impairment, she's I think they're just not clear that she actually was impaired. When you go from, her having good pulse and blood pressure, she answers all their questions appropriately. The EMTs on the scene say there's no sign of her ingesting drugs or alcohol. The first trooper says he doesn't smell alcohol. Her eyes aren't red or glassy. And, she's navigating difficult terrain up in this, mountain setting, trying to, get from one officer's car to the next. She doesn't need.
Didn't she crash a car and say, I just took hydrocodone? And she said that. I mean, I'm looking at light most favorable state, and I'm not saying, and I haven't got, and I understand that even if it is enough evidence, you have a prejudice argument on this other evidence coming in. But I mean, looking at light most favorable state, don't you need is just crashing a car with no, I mean, and admission that you ingested something and slurred speech or sleepy, being sleepy or seem to be out of it. I mean, I'm looking at light most favorable state. Why isn't that by itself just enough? I know a jury could go either way on it, but why isn't it enough to at least to get a jury to make that determination based on that evidence alone? And I'm not saying they didn't make the decision based on Miss Rowland's testimony also, but just without her testimony, why isn't that enough at least to go to the fact finder?
Sure. So my response is, the case law says that evidence of consumption of, a narcotic, for instance, is not enough. It's undisputed there was, she had 0.00 BAC. So
she admitted to taking something, and you have evidence that she crashed a car in a single car accident. I mean, why isn't that enough?
I think it's a really close call, and maybe, and her story is very consistent that in terms of what happened and why she crashed, that she was blinded by an oncoming truck, taking the curve, she dimmed her lights.
I understand that, but the jury can disbelieve that. I'm looking at the light most favorable to the state. I mean, I'm just trying to, if I take the light most favorable to the state, why isn't it enough to at least get to the jury on impairment, just on what, and I'm just looking, she crashed a car, she said I took hydrocodone and she appeared sleepy or whatever. And then they can disbelieve her story. I mean, would you say that would be at least enough to get to the jury? And I'm not saying she wasn't prejudiced by Ms. Rowland's testimony. I'm just saying, apart from that, was that enough to at least get to a jury?
I think that, Your Honor, it's a very close case, and I think that yes, I think that you can on that evidence. It could have gone either way, and the point I argue in the brief is, was there enough evidence for a reasonable fact finder to conclude beyond a reasonable doubt that she was appreciably impaired.
Okay, and then you're saying she was prejudiced because Ms. Rowland was able to say she probably did have hydrocodone, even though it wasn't, and she explained why. But is she prejudiced when she had already admitted at the scene that she had taken it?
I believe so, and I believe that is a really important point because, the jury, and this relates to the sufficiency issue. It's a close case, and maybe it goes to the jury. And here's why she's prejudiced for purposes of Rule 702. It's a close call. The jury deliberates for numerous hours, and when they are deliberating, they specifically, they ask for a couple things. The first thing they ask for is her Ms. Teesateskie's statement, which I've submitted as an exhibit supplement, which indicates to me they're really weighing both sides' stories. I mean, you had dueling experts. This question was heavily litigated. And then they specifically sent a note to the court saying, what did Amber Rowland testify about the confirmatory testing for a hydrocodone? So clearly it's in their mind. What did that expert say? Did she say it could have been there, but she couldn't? It's just, what did she say about that? And I think, and then they deadlock. They deadlock on the two counts involving the question of impairment, which are DWI and felony death by motor vehicle. And the trial court has to give an Allen charge on this. And so you have this deadlocked jury specifically asking about what did that expert say about the hydrocodone in her confirmatory testing. I mean, it's clearly, I think it is a reasonable likelihood that erroneous testimony impacted their verdict. I just think that the record is clear on those facts, and being a really close case, that there is a reasonable likelihood that it, like I said, it impacted their verdict.
So part of that, go ahead. I'm sorry. Go ahead, Judge Hunter.
Mr. Henson, I'm trying to make sure I have my timeline correct here. Of what the evidence shows. As I read the record, the timeline shows that your client admitted that around 9:30 she had a couple of drinks, or the last drink she had was around 9:30. And at around 9:30, she also took hydrocodone. And then the accident occurred, or somewhere around 10:50 is when, that's when the officers first arrived, was around 10:50. And she was then sleeping in the car, but there's evidence that they don't see any other evidence of impairment. They take a blood sample from her, and the lab testifies, Ms. Rowland testifies that I identified hydrocodone in the confirmatory test, but and then she says, just in the confirmatory test, however, it's one of those drugs that come out at the same time as latrum. I'm not pronouncing that correctly. So I can only get a good mass spectrum identification, which is like a fingerprint of the drug, and I couldn't get a good chromograph to show the relative size of this peak to determine that I could identify the peak. And there is no objection to that testimony. Is that correct? That's on page 419, I believe, of the...
Yeah, I was going to ask you what page that was.
I believe it's 419.
One moment, Your Honor. I just want to make sure I answer you correctly.
Your time, you appear to have plenty.
So at 419 now, the objection is at the first objection is at the bottom of the page in response to the prosecutor asks, can you explain how lamantrogen and hydrocodone, if they were present, why you wouldn't see that come out? And the analyst answers, so anytime we get a blood sample, before we run it on our instrument, we do an extraction process. Our extraction process is not, and then there's an objection. And again, so to answer your question, there was no objection above.
But so she had already testified that she had found hydrocodone in her confirmatory test, and no objection was made to that.
Correct. She says she identified it, and there is, if you look at the I guess my point is, she isn't asked, could it have been present, even though you could not confirm it? And that is the speculative and problematic testimony. And that is not what was specifically asked as of that point. Yes, Judge.
Just kind of to follow from Judge Airwood's questions here, the operative issue is her giving an opinion, not describing the test, correct?
Correct.
And so looking at what comes here at the beginning of 419, she's only describing the test as far as I'm seeing, and she's not giving an opinion of what those tests mean.
Yes, correct. Because it's under 702, it's the opinion that is problematic. It's not describe the test results. Did you identify it or not? That's a yes or no question. It doesn't require, her commentating on or offering an opinion on what that means, interpreting those results. And that's the problem when you say, well, could you have identified it? I mean, could you have confirmed it, even though could have been present, even though you couldn't confirm it? And that's what she offers an opinion. Yes, like it could have been present, but even though I couldn't confirm it. And the lab does not permit that themselves. I mean, she testifies during the voir dire, I wasn't allowed to report this out. It was only a 91% match. Some labs would have let you do that, but not ours. And that violates their own standards. I mean, that's indicative of a 702 violation when you're looking at, well, what are the sufficient, there's sufficient facts and data. Well, here she couldn't confirm it. So how is that a sufficient fact or data? Well, then, is it supported by reliable principles and methods? Well, no, the lab won't even let her testify to that. And she wasn't even allowed to report it out. And you can see in the record, page 117 and 118 is her report. And it's identified in a preliminary screening test, but they're not allowed to testify to that. And they has to be what is in the confirmatory report. And it says confirmatory testing for opiates were performed but not identified. And it's just, she couldn't say it in the report. She shouldn't have been allowed to say it to the jury. And clearly the jury really, and gave it a lot of weight and emphasis, so much that, they had to send a note during the deliberations about, well, what did that analyst say again about the confirmatory testing? And what they were asking for was essentially the opinion, the impermissible opinion that she offered. And the trial court said, you just need to recall the evidence. So they didn't get any help or clarity about this impermissible testimony at that point either.
And Mr. Henson, I'm looking at your brief. You raised a point that I hadn't thought about before, and I just wanted to make sure it wasn't something that was raised in the brief and I just missed it. But you brought up, in considering prejudice, the issue of the trial court having to give the Allen charge and having a deadlock. I have two questions related to that. The first one is, do you have any cases that you can point us to where an Allen charge or the need for the judge to give an Allen charge came into our prejudice analysis? And two, was any prejudice related, or the Allen charge and its impact on our prejudice review mentioned in your briefs or raised in your briefs at all? I'm just looking for it, and I just don't see it. I don't see any cite to Allen in your index. So if that was brought up, can you point me where that is in the briefs?
To answer your second question first, I don't believe I argued the Allen charge in the prejudice aspect of my brief. I think that is something that came to mind as I was preparing for oral argument in all candor. And if I've raised that for the first time, I think it would be appropriate for the state to be able to respond to that in a supplemental briefing if the court deems that appropriate. But with respect to your other question about do I know of any cases off the top of my head whether an Allen charge, how to take it into consideration for determining prejudice? I don't have a case or a cite off the top of my head for that. I think it just goes, my point is, it just goes to the question of whether, or it indicates that this was a close case, that you have a jury that's really grappling with the central questions, and ultimately guilt or innocence in a case where appreciable impairment was the issue really in question. And I think that demonstrates that there was a reasonable likelihood that the specific testimony that they asked about, which was the speculative testimony by the expert, it had a reasonable likelihood on the impact of their verdict.
And just one more, or Judge Dillon, is he in his rebuttal time at this point?
Yeah, but I'll give him.
I can ask him when he comes back on.
Okay. We'll give him 5 minutes if you need it because you're answering his question. So you come back. Okay. Okay, we'll hear from the appellee, Mr. Congleton.
Good morning, John Congleton for the state. If it please the court, I'd like to begin this chronologically and begin with the issue of impairment. This case has been characterized as a close case, and I would disagree with that, especially with regard to the issue that was raised on appeal, specifically the denial of the defendant's motion to dismiss. The standard review, of course, is was there substantial evidence, and more specifically, the court basically in applying that standard of review, the court must look at the evidence in the light most favorable to the state. The court does not engage in a reweighing. It does not look at the defendant's evidence that it presented in contradiction to the state's evidence. And the reasonable inferences to be drawn from from the evidence taken in the light most favorable to the state is what the court considers. In this particular case, that evidence was you had a person who drove a vehicle straight through a curve, hit a tree. When she was taken out of the vehicle, they did find a large amount of prescription drugs in the vehicle. The defendant, of course, there was some issue, some testimony about her shuffling or whatever. She's sitting in the deputy's vehicle at the scene of the accident while these emergency crews are trying to extract her seriously injured best friend from the vehicle, and she is nodding off and falling asleep in the deputy's vehicle. In speaking with her, the troopers asked her, and she specifically indicated she had drank alcohol earlier in the evening with a last drink at 9:30, which is approximately an hour and 15 or hour and 20 minutes before the accident, but 3 drinks in total. She also then indicated at some point, I think it was to Trooper McLeod, that she also took 2 hydrocodones at the time she had her last drink, which would have been 9:30. She indicated without further explanation that she had taken every one of the drugs that was found in the vehicle that day with the exception of the tramadol. The troopers indicated that she had red, I think it was bloodshot eyes was the term that was used, that she was unsteady on her feet, had mumbled speech, Field sobriety tests were conducted. I believe she had all 6 indicators of impairment on the HGN, 7 out of 8 indicators on the walk and turn, and missed 5 out of 6 attempts, in the trooper's opinion, on the finger to nose test due to touching the bottom of the nose with the pad instead of the tip with the tip.
Well, Mr. Compton, just real quick in regards to the indicators. Are any of those indicators approved tests to indicate the presence of the drugs that were included in the jury instructions, the Xanax and the hydrocodone?
Well, they were performed. Sorry.
But are they indicative of impairment for either of the drugs? I know, they're ones commonly used for alcohol, but are any of those commonly used or approved for the drug recognition?
My understanding is that they are, precisely because they were used by the trooper, who is a recognized, or use this term lightly, certified drug recognition expert. And he formulated his opinion, which he provided, that she was impaired on a CNS depressant, in part upon those field sobriety tests. And of course, he was subject to cross-examination later on.
And the CNS depressant, that's only the Xanax, though, correct? Or Xanax and alcohol as a depressant, but it doesn't include the hydrocodone, correct?
Hydrocodone, as I understand it, is a narcotic analgesic, analgesia, or in any event, it was characterized differently than a CNS depressant, yes. And the expert, Ms. Rowland, indicated that the Xanax was a CNS depressant. I think she also indicated, and I have the exact term here that she used later on, one of the other, the citalopram or whatever, she also indicated that that would depress the central nervous system as well. Plus, alcohol could be a CNS depressant as well, which is interesting because the trooper's opinion of her impairment, he indicated he believed that she was impaired on a CNS depressant, not on a narcotic analgesic. Yes. And in any event,
let me ask a follow-up from that then. If the trooper didn't give an opinion as to impairment as to hydrocodone, where does that opinion on impairment related to hydrocodone come in?
I don't believe there was an opinion that she was impaired on hydrocodone. I think the trooper indicated that he believed she was impaired. He indicated further that he felt like it was a CNS depressant based upon what he saw. I don't recall the trooper specifically saying he believed she was impaired on hydrocodone. If I missed that in the transcript, but I didn't remember him saying that. I specifically remembered him indicating that she had told him she had taken those. But the statement he made, at least as I recall it, was initially impaired on a CNS depressant.
And let me ask, just kind of feeding from that, I'm looking at the transcript, or actually it's the record, pages 132 to 135. The jury was instructed, including alcohol, alprazolam or Xanax, and hydrocodone are each impairing substances in both the DWI and the felony death by motor vehicle jury charge. So is that problematic if there's never an opinion as to intoxication on hydrocodone, that the jury is allowed to consider hydrocodone?
I don't believe that it's problematic, precisely because the defendant herself indicated that she took hydrocodone. So it's not, if we had this circumstance where all of that had been suppressed, let's say that the trial court had said, we're not getting into any of that, we're not even going to mention hydrocodone, then I think it might be problematic to throw it out there. But in this case, she testified she had taken it. The trooper testified she told him, the trooper testified she told him she had taken it 2 hours before the accident. And of course, the expert talked at great length. We'll get into that in a moment about.
But assuming there's no evidence, there's evidence of hydrocodone use, but if there's no testimony by an expert showing impairment related to hydrocodone, why doesn't that factor into our consideration of a motion to dismiss based on what was given in the jury charge?
Well, again, Your Honor, you're only looking at the evidence most favorable to the state, and there's a mountain of evidence favorable to the state that she was impaired. What she was impaired upon, and specifically in this case, she had the presence of those CNS depressants in her system, as well as a drug recognition expert's opinion that she was impaired upon those. The fact that there was these other drugs there, whether they were or were not impairing, I don't think impacts that at all.
But it's clear the jury could have convicted from these jury instructions only on hydrocodone. So it's listing all three as a substance for impairment in the jury instruction.
Well, Your Honor, I don't believe that was specifically what was argued by the defendant. But that being said, again, there was evidence that it was possible that it was there in conjunction with those other drugs. And I think that's sufficient to be considered.
Was there any objection to the jury instructions on hydrocodone by the defendant?
I do not recall there being one, Your Honor. Now, moving on from the impairment issue, which again, I would reiterate by the standard of review here, I think is clearly met. I also wanted to point out as well, just briefly, as defendant cites to Shelton, that case is sort of predicated on those cases of State v. Rich and Atkins v. Moy, and et cetera, that talk about if you have evidence of bad driving along with an indicator of impairment, that's a prima facie case. I think we're well beyond that with many indicators of impairment, as we previously discussed. And I would just say I think that the state prevails on that particular issue. Now, with regard to the second issue in the 702, I'd like to explain the state preserved the preservation issue on that for specifically in looking at the transcript. You have to kind of look at the timing for how this comes about. The Ms. Rowland, who is the expert, is testifying about the drugs that she found in the defendant's system. And then, interestingly enough, on page 416, I believe it begins on line 19, she was asked, "You've testified about the drugs that were confirmed in the defendant's blood. Does this mean there was nothing else possibly present in her blood?" And she testifies without objection, "It does not mean that. These are the drugs that I confirmed. The North Carolina State Crime Laboratory, we have to have 2 tests to confirm something." And then she goes into the screening test and then the confirmatory test, and they go along. And then she clarifies or explains several drugs come out within 4 seconds of each other. So when you have a drug like lamotrigine, which can be about 10 or 20 seconds on the chromatogram, it can overpower a drug that comes out at that exact same time. And all of this is coming out without objection, that there could be other substances in the blood that are masked by lamotrigine. And then as she continues on, she's asked, you remember what the defendant indicated she had taken, and she had. And then she asked, specifically, were you able to hear that she stated she took 2 hydrocodone at 9:30? And the witness indicated, yes, I did. And then the question that the prosecutor then asks is, can you explain the process of how that is eliminated from the human body system? And then she says, that drug specifically, that draws an objection. There's no objection to the fact that other substances can be present in the blood and masked by, or other drugs can be present in the blood and masked by lamotrigine. That's already before the jury without objection. The objection that is lodged here is about how those drugs are eliminated from the body. That is not this 702, whether it's there or not. And then that's when you have the question, the prosecutor comes back, or the state comes back, in your confirmatory testing only, did you see the presence of hydrocodone? The defendant, the expert witness testifies then without objection. I'm sorry, just in the confirmatory screening process is what they interjected. And then she said, in my confirmatory testing, I did identify hydrocodone. And then, however, and then they ask about what just in the confirmatory testing or in the screening. And then she explains in the confirmatory testing, and she then says it's one of those drugs that comes out at the same time as lamotrigine, and goes into how the chromatogram and whatever. So then she's asked, can you explain how lamotrigine and hydrocodone, if they were present, why wouldn't you see that come out? And she begins to explain that. When we get a blood sample, before we run it, we do this extraction process. Defendant at that point said, and she says, our extraction process At that point, the defendant objects. So it appears that they're objecting at that point at the extraction process, not the actual the fact or the fact that other drugs, specifically hydrocodone, could be in there and masked by lamotrigine. Now, at that point, it's already before the jury that other drugs can be there, can be masked by lamotrigine. There's no specific objection. That we don't have a motion to strike where she says identified it or the specifically that she identified it in the screening process. That's just left there. Now, there's then this voluminous back and forth once we're actually arguing the objection, and it morphs into, at least in part or up front, an objection to her being able to say that definitively that hydrocodone was in her blood. And the court rules that she cannot testify definitively that it was in the defendant's blood. The court basically rules, and it's kind of unclear. It appears to be that they're talking about 403, but the court's very clear through all of this in the end. I'm not going to let you say or testify that it's definitively in there. But because she has opened that door by saying, I took 2 hydrocodone an hour before this accident, that I am going to allow you to explain that there's a possibility the drug could be there, but is masked by lamotrigine, or won't show up for some scientific reason, which I think is appropriate, because it's going to confuse the jury to have this testimony that from her herself, basically, or at least to the trooper, that she's taking hydrocodone, but the blood test negative. So at any event,
Ms. Conkton, what in the record would indicate that that's a proper opinion for her to be able to give, other than the fact she's qualified as an expert? What makes that expert opinion, any methodology as to forming that opinion?
I disagree. I'm sorry, Your Honor.
What makes that an appropriate use of an expert opinion?
Well, Your Honor,
satisfy 702's foundational requirements.
Because the fact that the whole genesis of that you get into within the argument is that the expert witness herself can see and identify hydrocodone in the confirmatory process, in the confirmatory test. She can. She knows it's there. She goes through the science as to why it's there, why she can see it, and why she can identify it. The problem was not that you can't confirm whether, the problem is not what you don't know whether it's there or not. The problem is the lab's standards say that before you can put it on your report as being confirmed present, you have to then go in and extract out all these different drugs and then identify just that specific one. And as she explained in great detail, the problem is lamotrigine is much larger. And when she extracts out the lamotrigine, that process of extracting the lamotrigine strips away certain ions, 185 ions, in certain parts of the testing, that then when she looks at the hydrocodone, what's left of that after you remove what she calls the background noise, unfortunately, it actually strips away part of the hydrocodone that's visible in the initial confirmatory test, but is then removed when you go to the final confirmatory step. And so the issue is not from a scientific standpoint that she can't say, I saw it, it was there. The issue is her lab standards don't allow her, based upon what's left in that final step, to confirm it 100% as being there.
Well, aren't those lab standards based on scientific standards? And if it doesn't meet this threshold, I mean, that's the whole scientific process. If it can't be repeated and it doesn't qualify as reliable reading, then it's not scientifically present. Well, for an opinion. If the standard, if it was proper methodology, then there's no reason that the state lab would say that that's not an allowable opinion to base it off of on the initial test.
I disagree, Your Honor, to the extent that The witness testified after all the objections, consistent with the court's ruling that she was not allowed to say, I confirmed hydrocodone, and that's consistent with her lab's policy. But the fact that another drug can be present, but is masked such that it cannot be confirmed to a degree within the lab standards is a completely different issue. There's no speculation here that certain drugs are masked by lamotrigine. In fact, that very statement was testified to before the jury without objection in the beginning of this, that other drugs come out at the same time and they're masked by the lamotrigine. The fact that other drugs can be present in a person's system, but masked by another agent, in this case lamotrigine, was not objected to. It was before the jury, and it's good science. It's not an opinion that can occur. She testified as to the fact that it could occur, that hydrocodone could be there, and if it was, or if it were, it would be or could be masked by the lamotrigine. And that's a factual statement. It's not an opinion. Now, had she gone a step further and said, well, yes, I confirm that it is there based on what was left wouldn't meet her lab standard. And then I think you would run into potentially a 703, but also potentially a 403 issue of prejudice at that point, where you have someone basically testifying against their own standards. But in this particular instance, the fact that the hydrocodone could be present but masked by the lamotrigine is a statement of fact and is not an opinion.
Well, with that, and that's one question I had as I was going through the brief, is it a 403 issue in terms of the prejudice, or is it a relevancy issue in terms of it not mattering for this case about a general opinion of what masking does?
Well,
and since the methods used by the crime lab weren't ever brought into question, there was nothing really to rebut or to fix impeachment of the testifying witness. How is the testimony about the masking relevant?
Well, I'll begin by saying that I don't believe that was raised in the appeal. I don't believe that was the basis of the objection at all. But that being said, it is relevant precisely because there's testimony before the jury that the defendant takes 2 hydrocodone along with a beer, I believe it was, an hour and 15 minutes before the accident, but yet it doesn't show up on the test. So, yes, there is potentially some sort of, I'm going to use this term very lightly here, impeachment value. And I think that's what the defendant was trying to do, is saying, hey, you can't even, I'm going to basically impeach the fact. I'm going to impeach my own client backdoor by saying, hey, because it's not in there, she didn't take those hydrocodone, even though she told the trooper she did. But again, the whole purpose of an expert witness is to clarify those types of factual issues that arise before a jury and prevent confusion. That's what the expert did in this particular case. Now, the state also tried to go a bit farther in that same process and then say, hey, well, now that she said that she saw this in the original, or probably in the confirmatory test, we should be able to go a step further because that's an actual observation she made, and we should be able to get into that testimony. Of course, regardless of how we come down on that particular, whether or not that is allowable or not, it's the issue is the court said, no, we're not going down that road at all. So in this particular instance, it's the relevance really was not, I don't believe the relevance was ever what was being argued. There was, of course, it would, of course, I think, be prejudice. I think that the court indicated or sort of viewed it in the framework of it being prejudicial if the witness was allowed to testify after the voir dire there that the hydrocodone was definitively in the sample. But again, Your Honor, the problem there also is that cat was already out of the bag when the defendant, probably when the witness testified to that without objection prior to this objection to the extraction process. And why that's important is I think the fact that it's out there before the jury kind of goes towards the prejudice argument, because again, that cat's already out of the bag in multiple ways. Again, also because the witness testified that other drugs can be present in there but masked by the lamotrigine. All of this is already.
You're saying the defendant should have objected when Ms. Rowland testified. I saw hydrocodone at the confirming stage.
Absolutely, Your Honor.
Because I mean, you're trying to prove that she had hydrocodone in her blood, and you have it from her testimony. But the fact that she sees it at the confirming stage is not evidence at all, I guess, that to prove that fact. But she was allowed to say it without any objection, I guess is what you're saying.
Yes, and she did testify, and I think that was not what was objected to. I think perhaps in the course of the arguing of, or whatever they were going to argue, because interestingly enough, when you look at the way this works out, once they start arguing it, the trial court is engaging with the prosecutor vis-a-vis the objection and saying, hey, look, and the trial court steers this into, where I guess the trial court believes they are, about, hey, I'm not going to allow this testimony that it's there if you couldn't confirm it, because the trial court, I think, when you read through it, it's clear, is confused about whether it's confirmed or not, at least in part, because the witness through this voir dire is saying, I can see it. I know it's there. I can see the fingerprint of it. I can see the entire fingerprint of it when the lamotrigine is still there. But I can't see it or at least I can't confirm it to our lab standards after I rip the lamotrigine off of the top, because it takes things that I can see with it when it goes. That's my characterization, if you will, of the witness's testimony. So pardon that. But again, that was not objected to. There was no motion to strike. There was no, instruction given about that. It's already out there. This then morphs into, hey, you can't testify that it was definitively there. So, of course, when they come back onto the record, the expert witness is not allowed to testify, I confirmed it. She's not allowed to testify again that, yes, I was looking at hydrocodone and this ion and whatever. She wasn't allowed to explain that. But the trial court properly ruled that because she has indicated, the defendant has indicated that she took 2 hydrocodone with that last beer at 9:30, she can testify and explain why that may not show up in a drug test. And that's not an opinion. That's a fact. Here's why certain drugs may not show up or may not be confirmed. And also, I should point out as well, the record, the actual report, the lab report, was submitted into evidence, of course, with the appropriate redactions. And so, again, it's already out there that, hey, there's no hydrocodone in the report here. Again, I think this is the prime reason for having expert witnesses is to be able to resolve those types of conflicts, because otherwise, it's almost, you just kind of get into that point where you're hamstringing the state's ability to put forward factual evidence. And that's what we had in this case.
Mr. Collington, could you address the argument from the defendant regarding prejudice? Assuming we find that it is preserved, and should we find that it was there, or can you address the prejudice issue, particularly in light of the jury asking about the confirmatory test and a question, and in the fact that you needed to have an Allen charge in this case?
A couple of things about that, Your Honor. First and foremost, I don't believe there was any prejudice for a number of reasons. Number one, again, we've gone through, and I've shortened it somewhat, but a tremendous amount of evidence that would tend to show, or at least suggest, that the defendant was impaired at the time of the accident. Also, Your Honor, you have, of course, the DRE's opinion of that. And then you have the report itself, which indicates the presence of Xanax, the citalopram, if you will. And critically, and the one thing I haven't spoken about yet, but I really want to point this out, is that the trooper asked the defendant, basically, is it possible that you passed out or fell asleep from your medications and ran into the tree? I'm paraphrasing that. And she said yes. And then she continued on, I get very drowsy when I take my, and then it cuts off. The defendant herself had basically admitted the possibility that she passed out from her prescription medications and hit a tree. There's overwhelming evidence here of that I don't think you're going to get to a prejudiced argument. But more importantly, I don't think that she can be prejudiced by this scientific testimony, factual testimony, that drugs could be present that were masked by the lamotrigine, especially where the defendant herself has admitted to taking those drugs in close proximity to the accident. So I don't think that there's any prejudice there. And then as well, Your Honor, as to the Allen charge, these things occur all the time. There are ample cases where juries come back and say, we can't, we're done here. We can't reach a decision. They did ask that question, and the judge, I think, appropriately instructed them, you've heard the evidence and you have to go on your recollection. The trial court can't go in and sort of give you a synopsis of what it believes the testimony was, because then it starts intruding into the jury's ability to rely upon the evidence through its eyes, not through the eyes of the trial court or through plaintiffs or defendants' counsel. And so the court.
Could you address specifically what if any effect an Allen charge should have on our weighing of whether or not any error was prejudicial?
Well, again, Your Honor, and I'm going to predicate this with, if we were to determine that there was an error here in allowing her to testify.
And my question assumes that. I'm not saying that there was. I'm just saying, should we find that? Can you put in the state's perspective with respect to what the Allen charge has? Does that weigh in any way in our prejudicial analysis? Should we find error?
Well, I would say no, Your Honor, because I'm going to separate those two things. Asking about the testimony about the drugs does not go to them saying, hey, we can't make a decision specifically over whether she's impaired or not. I mean, it's kind of a corollary that may sort of be kind of hanging out there. But the issue is the jury ultimately made that decision. The jury could have hung. The jury could have, the trial court did the appropriate thing, as trial courts do every time a jury comes back and says, well, we're not reaching a result here. He gave them the appropriate instructions, and we presume that the juries, and I think there's ample cases that say this, though it's not necessarily brief, that we presume that the jury follows the instructions. And after being instructed with the Allen instruction, the jurors went back in, they deliberated, and based upon their deliberations, they rejected the defendant's evidence and they found her guilty of both charges. I think there's no prejudice, precisely because we presume that juries follow the Allen instruction, and they did, and defendant was convicted. And this court should uphold that conviction. Thank you.
Thank you for your argument, and we'll have rebuttal. Mr. Henson.
Thank you, Your Honor. A few things I'd like to clarify. First, there was some discussion about, Rule 403. You'll see in the voir dire that the trial court did make a ruling in regards to Rule 403, but that was simply with respect to the preliminary analysis done by the lab. That did not apply to the confirmatory analysis. The state also references, transcript testimony on page 416, and maybe objections should have been made there. But the expert is not rendering opinion testimony at that point. She's again answering factual questions about, does that mean there was nothing else possibly present in her blood? She's not asking there, was there hydrocodone and you couldn't confirm it? I think it's really important to look to see on page 419 why, and when the defense counsel makes his objection, they ask, can you explain how lamantrogen and hydrocodone, if they were present, why you wouldn't see that come out? And they start to answer that question, and that is when defense counsel objects. And that's when the opinion testimony is starting to emerge. And that is why that issue is preserved. Now, the state also contends that, well, the expert's testimony after they come back after the voir dire was not even calling for opinion testimony. But if you read that question and it says, is there any possibility that hydrocodone could have been present in her blood and you would not have been able to confirm it? That is asking for her scientific opinion. And what the analyst, and that draws the objection. And it's clear from the entire voir dire that specific testimony, could it have been there even though you couldn't confirm it, is what the trial court was concerned about on the basis of 702 and what defense counsel said was not scientifically reliable. And in fact, with the trial court's ruling during the voir dire, and she's not allowed to testify about hydrocodone being present in any respects. That was the trial court's language. And so for the state to then come back and say, well, could it have been present? I think that violates also the trial court's ruling. But, in addition to Rule 702, it was an abuse of discretion to let that in. It was calling fundamentally for expert opinion that just wasn't supported by reliable facts, sufficient facts or data, or reliable principles and methods.
Mr. Hanson?
Yes, Your Honor.
I'm sorry, I thought you were done. Go ahead, sir.
Oh, what I was going to say is, if you don't have sufficient facts or data, or reliable principles and methods in this case, then where do you draw the line in future cases? Can a forensic analyst in a future case come in and say, yeah, well, we think we identified blood or fingerprints on the murder weapon, but we couldn't see it, but it could have been there. I just don't know where you draw the line. And I think this is the whole speculative possibilities that Dalbert, Rule 702, McGrady, they forbid, they block this road off and they don't permit it. Speculative testimony from an expert, which we know juries give extra credence to, as this court has recognized, is prejudicial. And on the specific facts of this case, with the Allen charge and with the specific question about confirmatory testing during deliberations, there's a reasonable likelihood that this impermissible testimony affected their verdict. And for that reason, we ask you to grant Ms. Teesateskie a new trial.
Mr. Hess, let me ask you just two quick questions. The first is kind of procedural. I just want to be clear. I think when I go back and look at the video, there's some questions that Judge Dillon was asking you in part of your conversation there. You may have approached a concession on the motion to dismiss issue. Are you conceding that issue, sir, or is that just part of the conversation you were having with Judge Dillon and answering his questions?
Your Honor, I would submit that we still stand on our brief with respect to our argument on the motion to dismiss. I think that it is.
That's fine. I just wanted to be clear.
But I don't think I'm conceding it. Yeah.
And then on 33 through 35, you mentioned in your brief about issues related to the opioid epidemic and how that might influence the jury and prejudice your client. And in a vacuum, maybe that has some application, but given her admission to having used hydrocodone, how does this part of your prejudice analysis, how is it even relevant given the facts that we have here of her admission to having used hydrocodone versus the later blood test? I wasn't able to put those two dots together.
Sure. Well, I think there's a qualitative difference between having a defendant's uncorroborated statement. She says she took 2 hydrocodone in terms of the weight it carries with the jury versus the expert witness, a forensic analyst, coming in and saying, well, it could have possibly been there, even though we couldn't confirm it. And I think that connects to my point about prejudice with respect to this specific substance, hydrocodone. It carries a greater connotation in our society. Everyone is more generally familiar with that being a powerful narcotic in the midst of an opioid crisis. I just think it carries more stigma. And for an expert to say that, I think it clearly maybe more resonated with the jury as an impaired substance than these other 3 prescriptions that they didn't even quantify how much were in their system. And you have 2 defense experts saying, well, those are, pharmacologically indicative of impairment in this particular case.
Thank you, sir.
Thank you all for your arguments. We will take it under advisement. Mr. Storer, will you adjourn court this session?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
Thank you.
Thank you, Your Honors.
Have a great day.